Shrikant Anandrao Bhosale versus the state of Maharashtra. A Supreme Court judgment on Section 84 of the Indian Penal Code. The appellant Shrikant Anandrao Bhosale was a police constable. He married Surekha in 1987. On the morning of 24 April 1994, there was a quarrel between the husband and his wife. The appellant Shrikant hit his wife Surekha with grinding stone on her head. Surekha was taken to the hospital, where she was declared dead. Shrikant was formally charged with the murder of his wife. The Sessions Court convicted Shrikant for the murder of Surekha. The High Court affirmed the decision of the Sessions Court. Shrikant appealed to the Supreme Court.
The prosecution claimed that the appellant killed his wife not due to insanity, but out of extreme anger. Evidence from witnesses shows the appellant had a history of quarreling with his wife, drinking excessively, and getting excited, proving that he was a man of extreme anger by nature. The appellant has failed to prove he was of unsound mind at the specific time the offense was committed. Therefore, the fact that he had the mental illness before or after the event is considered legally irrelevant.
The appellant's lawyer presented evidence to support the plea of unsoundness of mind. The testimony and medical records of two doctors, Dr. Arun and Dr. Pramod, were central to the argument. The appellant was diagnosed with paranoid schizophrenia, a recognized mental disease. The defense claimed that this condition existed since at least 20th April 1992, and the symptoms included suspiciousness, persecutory delusions, loss of sleep, excitement, and visual hallucinations. There was also a family history of psychiatric illness in his father. He was first examined by Dr. Pramod on 20th April 1992 and was an inpatient at a government hospital from 28th October to 5th November 1993. He was taken to the hospital for treatment 25 times between 27th June and 5th December 1994. The doctors stated that paranoid schizophrenia is recurrent. And crucially, they testified that when a person is under a paranoid delusion, they are not fully aware of their activities or the consequences.
The Supreme Court held that the burden of proof rests on the accused, but it is not as high as the prosecution's beyond reasonable doubt standard. The accused only needs to prove their insanity based on a preponderance of probabilities, which is the standard used in civil cases. Even if the accused cannot conclusively prove insanity, the evidence can raise a reasonable doubt in the court's mind regarding the accused's mental state at the time of the crime, leading to an acquittal. The decisive moment for determining the accused's state of mind is the exact time when the offense was committed. This state of mind is inferred from the circumstances that preceded, attended, and followed the crime. The appellant's father had a psychiatric illness, and the appellant was also diagnosed with paranoid schizophrenia. He had been under treatment since 1992. He required hospital treatment 25 times within a short period. The alleged motive, as claimed by the prosecution, of his wife opposing his resignation was considered weak. The act was committed in daylight with no attempt to run away or hide. The Supreme Court looked at the totality of the circumstances, not any single factor in isolation. The proven unsoundness of mind before and after the incident was a highly relevant factor. The Supreme Court rejected the prosecution's extreme anger theory. Based on the evidence, the court concluded that the appellant successfully raised a reasonable doubt about his mental capacity at the time of the crime. Finally, the Supreme Court held that the appellant is entitled to the benefit of Section 84 of the IPC. His conviction is set aside, and he is to be released.
The ruling specifies that the accused's medical history is relevant evidence. The burden of proof is on the balance of probabilities. Mental state of the accused has to be judged from the totality of circumstances.
Thanks for watching.